Buildings webinar programme. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting, I'll just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please feel free to put your questions in the Q&A box at the bottom of your screens, and our speaker will come to your questions at the end if we have time. If you do not wish to be identified when you are asking your question, then please tick the anonymous box so that the speaker will not identify you in their response. And just to let you know, we now have a new section on the Five Stone Buildings website, which is just for webinars, which is where you'll be able to find the recording of today's webinar and any previous webinars that have taken place, together with any slides that are used. Thank you for joining us, and I will now hand over to Edward.
Thank you very much, Jo. Good afternoon, everyone, and a very warm, if somewhat virtual, welcome to this Five Stone Buildings webinar. I'm Edward Hewitt, and I'm going to talk to you today about will rectification. I've called the webinar Will Rectification an Update, because what I intend to do in this session is deal really with a brief update about two quite recent cases, both of which were decided last year, which both concern rectification of wills, and they are Kelly and Brennan and Barrett and Hammond. And they're both, it seems to me, quite interesting cases because they are perhaps, they raise issues which are perhaps not the standard run-of-the-mill will rectification cases that we see, but rather raise some new and in some cases quite knotty issues. And indeed some quite novel issues. Before I launch into the detail of those two cases and what their facts and decisions were, just a sort of refresher, I'm sure everyone is very familiar with the jurisdiction that the court now, since 1982, has to rectify wills, but by way of a brief reminder, that jurisdiction is Section 20 of the Administration of Justice Act 1982, which, as you can see from the slides, says that if a court is satisfied that the will is so expressed that it fails to carry out the testator's intentions in consequence A, of a clerical error, or B, of a failure to understand his instructions, the court may order that the will shall be rectified so as to carry out his intentions. And subsection 2 is also important, and we'll see that particularly Kelly and Brennan talks about section 2. Section 2 imposes a time limit in the following terms: an application for an order under this section shall not, except with the permission of the court, be made after the end of the period of 6 months from the date on which representation with respect to the estate of the deceased is first taken out. Subsections 3, 4, and 5 I haven't set out on the slide. Subsection 3 effectively provides personal representatives with some protection in the event that they have distributed to the estate after the period of 6 months referred to in subsection 2. And subsections 4 and 5 exclude certain types of grants of representation from the ambit of section 2. That is to say, subsections 4 and 5 tell us which grants don't count in terms of setting the 6-month clock going for the purposes of subsection 2. And again, this is probably familiar territory, but just by way of a brief recap, Rees-Siegelman was a well-known decision in which Mr. Justice Chadwick, as he then was, identified what he said are effectively the 3 questions that the court needs to ask itself when dealing with a claim for rectification brought pursuant to section 20. The first question is, what were the testator's intentions with regard to the dispositions in respect of which rectification is sought? The second question is the will so expressed that it fails to carry out those intentions? And the third question is the will expressed as it is in consequence of either a clerical error or a failure on the part of someone to whom the testator has given instructions in connection with his will to understand those instructions. This is the approach that has been adopted, I think it's fair to say, in every single rectification claim since Siegelman was decided. The important point perhaps to note at this stage is that what this three-stage approach allows is, in particular at stage 1, is an inquiry into extrinsic evidence of the testator's intentions. Normally, of course, in the case of a professionally prepared will, the main piece of evidence one will be looking at is the attendance note of the solicitor, and that's normally the evidence which one looks at to see whether the testator's intentions, as recorded in that attendance note, have not quite made their way accurately into the will, so that when you then look at the second stage and you say, well, what does the will mean as a matter of construction, you find that there is a mismatch between the testator's intentions and what the will actually, as expressed, does as a matter of construction. So that's just a brief recap of how rectification pursuant to rectification claims work pursuant to section 20 and the three-stage Siegelman approach. Kelly and Brennan, I will spend a little bit more time on because it raises, I think, some more and quite interesting, and in one aspect in particular, some quite knotty issues, knotty conflict of laws issues. The fact that it was a decision of Master Schumann on the 12th of February of last year, so in fact exactly a year ago as it happens. The facts briefly were these: the deceased was born in Ireland in 1934. He was one of 9 children, and he moved to England in the early 1970s, where he worked as a joiner all of his life. He never returned to live in Ireland in any permanent way after the early 1970s, so his home was England, but he visited Ireland quite frequently. Some of his siblings continued to live in Ireland, so he visited them. He didn't marry, he didn't have any children. In August 2006, the deceased gave instructions for and then made what was to be his penultimate will, and he used for those purposes a firm of solicitors in Ireland who, it seems, were the very long-standing firm of the family, if I could put it that way. There was evidence that I think the testator's father had previously used the firm, and indeed the firm was a family firm, so there was a relationship between the father of the deceased and the father of the solicitor who the deceased himself then used. So a quite long-standing relationship between the family and that firm. So the deceased gave instructions and made a will in Ireland using the services of his long-standing Irish solicitors. In 2010, he then bought a flat in West London, and in that same year, he gave the same firm of solicitors in Ireland instructions for a new will. And at that point, by the 5th of July 2010, he had 6 living siblings, 6 siblings who were still alive. 2 of his siblings, James and Maureen, had predeceased him. And the attendance note of the solicitor who took instructions in relation to this will on the 5th of July 2010, in relation to residue, said this, as you can see from the slide: residue including English property to sister Eileen Delaney, Kathleen Kelly, wife of deceased brother James, brothers Michael, Vincent and John, and the children of his deceased sister Maureen Brennan, namely Mary, Matthew, Fergus, Vincent and Damien Brennan, in equal shares, subject only to payment of my debts, etc. By equal shares, I mean 1/6 to each of my siblings and remaining 1/6 equally between children of Maureen Brennan, deceased. That was the attendance note. It seems from the judgment that the will-making process, in fact, all took part on the same day, and it seems that the solicitor dictated the will to his daughter, who he had employed as a secretary. The daughter then typed it up, and the will was executed by the deceased, it seems, on the 5th of July 2010, so on the same day. The will, there was a separate gift of land which the deceased owned in Ireland, which he had inherited from his parents, to 2 of his nephews. And then the gift of residue, as it appeared in the will itself, read as follows: my sister, Eileen Delaney, my sister-in-law, Kathleen Kelly, wife of my deceased brother, James Kelly, and my brothers, Michael Kelly, John Kelly, and Vincent Kelly, and my niece Mary Brennan and my nephews Matthew Fergus, Vincent and Damien Brennan, the children of my deceased sister Maureen Brennan, in equal shares absolutely, subject only to the payment of my debts, funeral and testamentary expenses. So you can see there immediately the problem. The attendance note made it quite clear that the intention was a six-way split, if I can put it that way. 1/6 share should go to each of the 5 surviving siblings, and the remaining 1/6 share should be split between the 5 children of the predeceased sister Maureen. Whereas, of course, on the face of the will and the wording that I just read out, what the will actually did was split residue 10 ways equally between both, on the one hand, the surviving siblings, and on the other, the 5 children of the deceased predeceased sister Maureen. So that was the mismatch, that was the problem. Just to follow through with the chronology of events, on the 9th of June 2014, the deceased died aged 80. On the 7th of November 2014, an English grant of probate was issued to the claimant. The claimant was one of the surviving brothers, Vincent, who was both, as we've seen on any analysis, one of the residuary beneficiaries, but he was also appointed the executor. So Vincent took out an English grant of probate. The estate in England was sworn at about 1.6 million. The period, of course, the 6-month period we've looked at, imposed by section 20, subsection 2, expired 6 months later, so on the 7th of May 2015. Sometime later, in April 2016, an Irish grant of probate was issued to Vincent, and the Irish estate was rather more modest. It was sworn at 80,000 euros, and it effectively consisted of a property which, as I say, had been specifically gifted by way of a separate gift in the will to 2 nephews, named nephews of the deceased. The claim for rectification was issued on the 1st of May 2018, so just under 3 years after the expiry of the 6-month period imposed by section 20, subsection 2. It was brought by, as I say, Vincent, one of the deceased brothers, who was, he brought it as a beneficiary, as a residuary beneficiary, although he was also an executor, and he brought it against the 5 children of Maureen, who of course would be those adversely affected by the rectification, those who stood to lose out. It was in fact opposed by only, it seems, 2 of them. Now, the issues for the court were really 3. The first question, which is perhaps the more difficult and actually perhaps the most interesting one, is could the English court rectify this will, given that this will was an Irish will made in Ireland? The second question was there a clerical error, or was the error in question a clerical one? And the third question was, should permission be granted to the claimant to pursue this claim out of time, notwithstanding that, as I say, it had been brought nearly 3 years after the expiry of the 6-month period imposed by section 2, subsection 2 of section 20. So taking those in turn, the first question, could the English court rectify an Irish will? Well, the answer that the judge, that Master Schumann gave to that question was yes. I've put on the slide brackets on the facts, as we will say, as we will see, because I don't think one should take this as a general proposition. I think it is, because of the reasoning, which I'll come on to in a moment, I think it's fair to say that the answer is yes on these particular facts, but it probably is going to be a fact-dependent question in other cases. Now, a first point what was made by the defendants, who argued that the court simply couldn't rectify this will at all. And the argument was based on section 77(1)(c) of the Administration of Justice Act 1982, which is a provision that says sections 17 to 22, so including section 20, extend to England and Wales only. And the defendant said, therefore, the English court has no business in rectifying a Irish will. However, the Master rejected that argument and said, well, there's a distinction, a well-known distinction as a matter of statutory interpretation, between the extent of a statute and an application of a statute. And the distinction, in essence, is that the extent is the geographical area throughout which a particular statute is law. To put it another way, the extent is concerned with the jurisdictions which the Act forms part of the law of, whereas the application of a statute concerns the people, places, and things to which an Act applies, or to put it another way, it concerns the question when an Act has a practical effect. And so Master Schumann said, decided that Section 77 wasn't really engaged with this question, because Section 77 deals with the extent of the Act rather than its application. It clearly extends to England and Wales only, and so it's part of the law of England and Wales, but it does not answer the question, when does it apply? It does not concern the separate question of application. So that argument was rejected. And then Master Schumann looked at whether there was any guidance and previous authority on this question, and it seems there wasn't. She said, I've struggled to find anything, really any specific guidance on the particular question of will rectification in a conflict of laws international context, either in Dyson Morris or in Theobald. And she decided that it's quite interesting to read her reasoning, but she ultimately, in short, decided that in terms of best fit, she said, I consider that rectification is more obviously analogous to the examples given in respect of essential validity. So those of you familiar with conflict of laws, the idea of essential or material validity of wills in a conflict of laws context is that essential or material validity are those issues which deal, for example, with questions whether a will, a will or a gift in will can take effect notwithstanding, for example, local forestairship rules. So it's a distinct category of issues from those that govern formal validity. The reason that is important in a conflict of laws field is because when one is dealing with an issue of material or essential validity, the two are used as synonyms, those issues are governed as follows as a matter of conflict of laws rules. If the gift in question is a gift of movables, then the law which governs issues of material or essential validity of gifts of movables is the law of the testator's domicile at date of death. Whereas if the issue in question is the material or essential validity of a gift of immovables, then the law which governs that issue is the lex situs, that is to say, the law of the country in which the immovable is situated. And the movables-immovables distinction, again, is a well-known distinction in a conflict of laws territory. So how does all of that apply here? Well, what that meant in practical terms was that Master Schumann had to decide where the deceased was domiciled, and she decided there was ample evidence to say that he was clearly domiciled in England, although his domicile of origin on the facts was Irish. He had clearly moved to England in the 1970s in a very permanent way, if I can put it that way, and there was ample evidence the Master referred to which supported the conclusion that, and led her to the conclusion that he had acquired a domicile of choice in England, and that domicile of choice was still existent at the date of his death, and therefore he died domiciled in England. And then she said, that means that English law applies. And she said this, here the 2010 will has been admitted to probate in order to give effect to the deceased testamentary intention. I am concerned with the application of the 1982 Act to the administration of the estate in England. This is also consistent with wider principles of private international law and the autonomy of the deceased in selecting England as his country of domicile. It therefore makes sense for the law of the deceased domicile to determine issues of essential validity and construction in respect of movables including this claim for rectification. And so she decided that the court did have power to apply English law, including Section 20, and therefore rectify this particular will. Now, a couple of points I think that are worth highlighting. On the reason I said at the beginning, it seems to me this is a relatively fact-specific decision, is because one feature is that it was common ground that the rectification claim did not affect the specific gift in the will of the Irish property, which of course is Irish immovable property. Now, the residue, as we've seen from the previous slide, which let's go back to, the residue appears to have been characterized as movable, and you see that from the very last line on the slide, issues of essential validity and construction in respect of movables, including this claim for rectification. Of course, the claim for rectification concerned a gift of residue, and it appears the gift of residue was characterized as a gift of movables, which one might pause and think whether that is in fact correct, given that we know from the facts that what residue in this particular case comprised was some investments which appear to have been in England, English investments, so English movables, but also a London flat, and of course that is immovable property. It was a long lease of the London flat that the deceased had bought in 2010. So there was arguably residue comprised both movable and immovable property. However, on the facts, of course, that wouldn't have made any difference to the analysis, because, as I said earlier, the gift of movables would have been an issue of essential validity of the gift of movables would have been determined in accordance with the lex domicilii, the law of the country of domicile of the testator at date of death. And we know that the master found as a fact that that was England, because he died domiciled in England. And of course, even if one had decided that the gift of residue also comprised a gift of immovables, namely the London flat, and therefore the lex situs applied to that gift, it was a London flat, therefore English law would have applied anyway. So no difference, the characterization of residue as movable wouldn't have led to a different outcome had it been characterized differently. But one can see, and I asked rhetorically on the slide, what if, for example, this rectification claim had affected a gift of foreign immovable property, namely, in this, for example, here, the gift of the Irish immovable property. There you can see there might have been more of a problem in applying, by way of this reasoning, which I hasten to add, I don't disagree with, the characterization of rectification as a material validity point. But you can see there might be a problem there where you have a gift of immovable property abroad, and you're trying to rectify a gift of that nature pursuant to Section 20. So that's the sort of interesting, quite novel, it seems to me, and quite knotty issue, first issue from Kelly and Brennan. The second question, was there a clerical error? The answer was yes, said the master. She referred to the well-known passages from Lord Newburger's judgment in Marley and Rawlings, the unanimous Supreme Court judgment in Marley and Rawlings, where Lord Newburger said that the expression clerical error should be given a wide meaning, and the master decided on the facts of Kelly and Brennan that unfortunately there was a clerical error when the 2010 will was typed up. It should have recorded that the residue was to be divided into 6 equal shares and then identify the beneficiaries to whom those shares were to be divided. Instead, it simply listed all 10 of the beneficiaries and then added in equal shares absolutely, as we've seen. The effect of that was to divide the residue into 10 shares and not 6. I do not know, she said, whether the error occurred in Cyril Osborne, that's the solicitor's dictation of the wills and of the will instructions to Brona Osborne, his daughter, or as she typed up the will. It is plain that a mistake arose that was not corrected when the 2010 will was executed. I accept Mr. Baumer's submissions that this was a clear clerical error, arising out of office work, and that it is a strong case for rectification of the 2010 will. And the third question in Kelly was, should permission be granted to bring the claim out of time, as I say, despite the fact that it was effectively 3 years out of time? The Master said yes, and she added, I think, what are some very interesting and actually quite helpful comments in the rectification context. We know from Chittick and Stevens that the judge in that case decided that when the court is approaching the discretion it has under section 20 subsection 2 to grant permission to a claimant to bring a rectification claim, notwithstanding that more than 6 months have passed since the date of the grant of probate, the court should apply by analogy the factors effectively that are relevant to the court's exercise of the analogous discretion in the context of 1975 Act claims. So the court in Chittick and Stevens says it's a similar approach to when you decide in a 1975 Act claim context whether under section 4 the claimant should be given permission to bring the claim, notwithstanding that it's being brought more than 6 months from the date of the grant. But in Chittick and Stevens itself, the judge had suggested a degree of caution. He said, while a claim under the 1975 Act for provision out of the estate is one to overrule or derogate from the testator's intentions, a claim for rectification is concerned to ensure the proper implementation of his wishes. So there's an analogy, but the analogy perhaps should not be taken too far. And Master Schumann in Kelly very much endorsed that. She said to simply align the guidelines from applications under section 4 to applications to extend time under section 20, subsection 2 is to disregard the fundamentally different nature of these claims. The former can effectively drive a coach and horses through testamentary intention, whereas the latter seeks to find the true testamentary intention and give effect to it by rectifying the will. Whilst noting that section 23 of the 1982 Act is analogous to section 20 of the 1975 Act, I do consider that section 20 of the 1982 Act is and should be more flexible than the 1975 Act. Now, as you know, there's been a flurry of activity recently in 1975 Act claim context, and arguably the Court of Appeal suggesting that one shouldn't take certainly the rather strict approach that was taken by Mr. Justice Mostyn at first instance in Cowan, but a slightly more relaxed approach in a 1975 Act context. And one can see that Kelly rather suggests that if anything, the court is going to be even more flexible in a rectification context, because of course what one is trying to do here is in fact to give effect to the testator's wishes, the true wishes, the true intentions, which if the claim is correct, haven't been properly recorded. And so a potentially helpful indication that there is a willingness to be flexible on behalf of the court, even if the claim is perhaps out of time. Now, that said, of course, one shouldn't take that too far. And if you read Kelly and Brennan, you can see that there was a fairly thorough analysis of quite what had happened before and then after the expiry of the 6-month period up to the date on which the claim was eventually issued 3 years late. So that you still need to put forward an explanation as to why it is that the claim is being brought when it is being brought. And there was also an analysis of the salmon and re-salmon and Berger factors that one looks at in the 1975 Act context. So it's not a sort of carte blanche. We shouldn't take it too far and simply ignore the time limit. But I think a helpful indication that the court might be willing to take a fairly flexible approach to the 6-month time limit in a rectification context. And she says, just following through with that point, that is demonstrated by the more flexible approach to the meaning of section 21A to the Act as set out in Marley and Rawlings, and Theobald on Wills makes the additional point that there are practical reasons for the flexibility. Rectification claim, another point made by the master, is often an alternative to a claim for a declaration as to the true meaning of a will, so a construction claim, and the latter has no time constraints and significantly no protection for the executor. There's a potential risk that if there was too restrictive approach to a time limit under section 20, a court may, in trying to achieve a result where the will truly reflected the testamentary intentions, strain too far in that interpretation. That could lead to an executor being exposed many years later for distributing on the wrong basis. So another reason why the court thinks there should be flexibility in approaching this 6-month time limit. A further and final point on Kelly, which struck me as quite an interesting one, is there was some discussion about whether, notwithstanding the enactment of section 20 in the 1982 Act, there was still a residual common law, limited common law jurisdiction to rectify wills. And that was a point which some of you will know was touched on, but effectively left a little bit to one side in Marley and Rawlings. And there was quite a detailed and thorough analysis of that in Kelly. And a point which the master made in terms of, she suggested that there was a potentially different way of getting to the same result in Kelly. And that is, she said, well, first of all, Section 21 of the Administration of Justice Act 1982, which is the provision that allows the court to look at extrinsic evidence of the testator's intention in construing a will in certain circumstances. She said that was not engaged because the will was not meaningless on its face, and no part of it was ambiguous, whether on the face of the will or in light of surrounding circumstances. So a construction claim would not have helped because the will was clear on its face, and in a construction claim, the claimant would not have been able to ask the court to look at the extrinsic evidence of the testator's intention, namely that crucial attendance note of the solicitor. However, the master said what the alternative route could have been would have been to ask the court to omit the words "in equal shares absolutely," the concluding words of the gift of residue, under the limited common law jurisdiction which existed before the 1982 Act. Re Morris is an example of that from the 1970s. The court says there is a limited jurisdiction to omit words from probate. And if the court had decided to go down that route, the result would have been effectively to create the ambiguity by removing the "in equal shares absolutely" for concluding words, create the ambiguity which then could have been resolved by construction. Of course, a more roundabout way, as the master recognized, but one that she indicated in principle would have been open to the claimant and might have been another way in which the same result could have been reached. Would have been open to Vincent on the first category identified by the committee, that is the limited jurisdiction to omit words, as I say, to argue that the 2010 will could have been rectified in the common law sense by the removal of the words "in equal shares absolutely." That would have led to an ambiguity as a matter of construction. The court could have admitted evidence under section 21 of the deceased testamentary intentions to cure this ambiguity. The claim form sought such further or other relief as the court thinks fit. Mr. Bowmer submitted that if I refuse the rectification, the claim for rectification under section 20, I could grant relief via this somewhat more circuitous route, and I agree, said the master. So that is Kelly and Brennan, and moving on to the second case, which I can deal with rather more briefly. Barrett and Hammond was decided more recently on the 6th of November of last year by His Honour Judge Kramer, sitting as a High Court judge. The interesting aspect, it seems to me, of Barrett and Hammond is that it involves, as we will see, the rectification of a codicil rather than rectification of a will, or perhaps more accurately, as we will see, the rectification of provisions of a will incorporated into and republished in a codicil. Not a scenario, I must say, that I have seen very often. So a good example of how the court might approach rectifying a codicil. The facts, very briefly, were that on the 29th of September 1998, the deceased had made a will by which he gave the residue of his estate to be divided into 52 parts, of which 6 named individuals should receive 6 parts each, so 36 parts in total, and then 8 charities should receive 2 parts each, so 16 parts in total. He then made a first codicil. There's a second one which is not as relevant, but the first codicil on the 2nd of August 2005, and by that codicil he deleted the gift to 2 of the individuals, so a total of 12 parts, and inserted, added new gifts of 2 parts each to 2 additional charities, so new gifts in relation to 4 parts. And of course, the mathematicians among you will have spotted that the problem that raised, or gave rise to, was that 8 parts remained undisposed of. Now, to look at it in a little bit more detail on the actual wording, the will had said this: to divide the remainder of my residuary estate and to stand possessed thereof, to divide the same into 52 parts upon trust, 1 as to 6 parts to Sydney, 2 as to 6 parts, etc. 3, 4, 5, 6. That's the 6 parts to the 6 individuals, provided always that in the event of any of the foregoing bequests of my residuary estate failing, then that part shall accrue to the other foregoing part or parts, and if more than one, in the proportions which they bear to each other. And then there was a similar gift. We don't know the precise wording because the judge gave an extemporary judgment and it wasn't read out, but a similar gift of 8 sets of 2 parts to 8 identified charities. So 2 parts, one imagines the wording would have been as to 2 parts for charity X, as to 2 parts for charity Y, etc., in relation to the 8 charities. What the codicil did was this. It said, my will shall be construed and take effect as if clauses 8K, which is not relevant for present purposes, 9.1 and 9.3 of my will shall be deleted in their entirety. Pausing there, this, going back one slide, the gift of the that I've read out from the will, the gift of residue, was clause 9. So that deleted the part that says, as to 6 parts for Sidney Arthur Higgs, and then subclause 3, as to 6 parts for Ellen, known as Eileen Gertrude Higgs. So those clauses were deleted effectively. And then subclause 2 of the codicil said the following bequest shall be added to clause 9 of my will, as to 2 parts for the Royal Institution of Great Britain, and as to 2 parts for the Dogs Trust, and then the address was given. In all respects, I confirm my will. So quite a short codicil. Now, as I mentioned earlier, there was a second codicil made on the 1st of March 2016, and that changed the appointment of the executor and directions in relation to burial, but that didn't of itself cause any particular problem. The sole executrix brought both a construction and a rectification claim. And obviously the issue was, were 8 parts, did 8 parts pass on a partial intestacy because of the way, because of the combined effect of the codicil and the will. The rectification claim was stayed pending determination of the construction claim. The construction claim was decided by Master K, and she held that on true construction of the will and codicil, a partial intestacy did indeed arise in relation to 8 of the 52 parts. And so His Honour Judge Kramer said, well, dealing with the rectification claim, he said, so the question as to whether there is scope to rectify in this case is really determined by my finding as to the testator's intentions, because the will has already been construed by Master K. If it was his intention to dispose of the whole of his estate and not to leave a partial intestacy as to those 8 parts, the will certainly does not carry out those intentions. And that's a reference back to the Siegelman test. Didn't have to consider stage 2, what does it mean as a matter of construction, because Master K had already decided that question. Really, one had to look at what were the testator's intentions, and then, if there was a mismatch, between those intentions and the will as properly construed was that caused by clerical error. And there was, on the facts, plenty of evidence that the deceased clearly had not intended a partial intestacy. The deceased and his wife had made mirror wills, and there were, it seems, a number of documents in which had survived, in which they had, over the years, changed quite what parts should go to whom, and had made sure in those documents to change the total, to sort of tally up, make sure that the total of parts did in fact tally up, changing the 52 total to, for example, 40 or 44 or 42, depending on how many gifts they had made. And that was one of the bases on which the judge said, well, there's a clear evidence that they did not intend a partial intestacy. The deceased did not intend a partial intestacy. And of course, he was reminded of the well-known statement from the Victorian case of Reed Harrison that when a testator has executed a will in solemn form, we must assume that he did not intend to make it a solemn farce, i.e. the court should normally assume that a testator who goes to the trouble of making a will does not intend to give rise to a partial intestacy. So plenty of evidence that he did not intend to give rise to a partial intestacy. The next question was, does section 20 apply to codicils at all? Now, of course, as I set out at the beginning, the section itself talks about wills, and it's fair to say that, as the judge pointed out, he had to look into the question, well, does that include codicils or not? And he said, during the course of the hearing, I had to look a little further into the laws. There was a question as to whether the 1982 Act could amend a codicil. It's quite clear from Section 1 of the Wills Act 1837 that the definition of will includes a codicil. So although Williams and Wills assumes that it can be used to rectify a codicil, if one needed authority for that proposition, it comes from the fact that a will includes a codicil for the purposes of the 1837 Act. There is no other definition of will in the Administration of Justice Act 1982. So for a will, we can read including codicil. So that's how the judge decided that yes, section 20, although it specifically talks about wills, that and the 1982 Act does not define will, that definition should be read as including a codicil. The question of, I've put it as a question of mechanics of rectification of a codicil. How does it quite work? Well, helpfully the judge explained, well, the effect of confirmation of the will, which appears in both the 2005 and the 2013 codicils, had the effect of bringing the dispositions of the will down to the date of the codicil, as if a new will had been made, and amounts to a republication of the will. As the codicil is annexed to the will, the two are to be construed as one testamentary disposition. That's not a novel proposition, but helpful when one thinks about rectification. Of course, if you have a codicil that otherwise confirms the will, as codicils normally do and should, then the effect of that is to bring into the codicil, so to speak, to republish in the codicil, all of the provisions of the will which are not affected by the provisions of the codicil itself. And so that is what gives you the provisions you're looking at. It's the codicil combined with the unaffected provisions of the will which have been republished. The error, the judge said, was clearly a clerical error. Marley, again, he referred to Marley and Rawlings, and he said in this case, what the solicitor needed to do was to appreciate that unless something was done about the number of parts into which the residuary estate had been split, there was going to be a partial intestacy. The fact that the solicitor did not apply his mind to it is evident from the letter which he sent with the draft codicils, which made no reference to the mismatch. That is something I would expect to appear in the letter. It seems that the way that the instructions were given is that the deceased and his wife wrote to the solicitor and said, we want to change these. Can you please give effect to these changes? And then the solicitor produced a codicil and sent it by letter to the deceased and his wife. And as you can see there, the judge said, well, had the solicitor spotted the point, he would have no doubt have raised it in his covering letter to the deceased with which the draft codicil was sent. So that should suggest he simply didn't spot the arithmetical problem. Whilst there was a carve-out, he says, in Mali for the exercise of specialist services, which in fact, let me read this in full. Whilst there was a carve-out for the exercise of specialist services to be found in Mali, which would more properly fall under Section 21B of the 1982 Act, rather than within the category of clerical errors under Section 21A, there is nothing particularly specialist about appreciating that if one starts with 52 shares but only dispose of 44 of them, 8 of them remain undisposed of. Quite apart from the sort of amusing aspect of the second bit, I should perhaps comment on that as some of you will know, the difficulty that one sometimes encounters with the idea of the carve-out for specialist services, which Mali does talk about, is that in fact the problem is where you have an advertent error by the solicitor who gets the drafting wrong, you risk not only not falling within Section 21A, clerical error, but actually you don't even fall within Section 21B, failure to understand instructions, if the instructions have been properly understood. And those are the sorts of cases where unfortunately you risk falling, so to speak, within the cracks of Section 20, and you can't get rectification at all. So that's just a little sort of caveat to the first 3 lines of that statement. But of course, on the facts, the judge rightly, it seems to me, says this is not particular expertise, it's simply a mathematical error, and it's the sort of and that sort of error is in the nature of a clerical error. The reconciliation of the figures did not require any particular legal expertise and does not point to a misunderstanding as to the instructions. It was just a clerical oversight, a failure to balance the figures so that at the end of the day, the number of shares disposed of coincided with the total of the parts. The way this can be achieved, given that the codicil can be rectified, is to put it in the form it should have been had the solicitor paid sufficient attention to the impact of the change wrought by the codicil, namely, and this is the mechanics of the rectification, to add words to the codicil to reflect the change in the number of parties among whom the shares were to be distributed. That can be done by rectifying clause 9, and I've added note, that's clause 9 of the will, so that it reads, subject thereto to divide the remainder of my residuary estate and to stand possessed thereof, to divide the same into, and then delete 52 parts and insert 44 parts. So just to be clear on that, you will see that although what is being amended, what is being rectified is the codicil, that's where things have gone wrong. In fact, what is being done is clause 9 of the will, which is republished into the codicil, because once republished, it doesn't work, it doesn't add up to the right total. It is that clause 9 as republished in the codicil that is rectified, that is amended by the deletion of the word 52 parts and the replacement with those with 44 parts. And that's the sort of an illustration of the mechanics of how rectification might work where you have a codicil. That's all I wanted to say on Barrett and Hammond. A final quick and cheeky plug, if I may, for those of you who are desperate for further reading and have been kind enough to stay online this long. You can find a little bit more information about this in a little book I wrote on construction and rectification of wills and indeed of trust instruments, which is a different chapter, different aspect altogether. And if you buy it directly from the lovely people who publish it at Law Brief Publishing, using the coupon code you see on the slide, you get a little discount. So thank you very much indeed for joining me. And now I will see if there are any questions in the Q&A box, or feel free to type any if you have any. I can't see any here, so what I'm going to suggest is that I bring the webinar to a close. You see my email address on the slide. do feel free to get in touch if there are any questions that you think of after the seminar and that you want to ask, or any aspects that you want to discuss with me. Do feel free to get in touch and ask. Otherwise, that's it from me, and thank you very much indeed for joining, and